Attorney Don Harris in Albuquerque, New Mexico. Learn about Chapter 11 bankruptcy laws in this video. Chapter 11 is a part of the United States Bankruptcy Code, and it is the most complex section of the bankruptcy laws. Chapter 11 was designed for businesses, often medium and large businesses with financial difficulties. However, a highly specialized bankruptcy attorney can use Chapter 11 for individuals with high incomes, high debt, or a need to rewrite long-term obligations that cannot be rewritten in any other chapter of the Bankruptcy Code. Chapter 11 has a significant advantage over other chapters in that there is no trustee appointed in Chapter 11. Once an individual or business files for Chapter 11, the individual or business remains in control of the affairs of the individual's property and finances or the business's assets and operations. An individual or company that has filed for Chapter 11 is called a debtor in possession. A debtor is what Congress calls a person or a company who has filed for bankruptcy. In possession means that the debtor has filed for Chapter 11 and is in control of their own assets and operations. A debtor in possession has significant responsibilities that do not exist in other bankruptcy chapters. A debtor in possession must file detailed monthly operating reports, pay quarterly fees, and open a new bank account. All of their bank statements will be filed with the bankruptcy court, so after filing for Chapter 11, the debtor can no longer conduct affairs in cash, and expenditures must be reasonable. Chapter 11 also tends to be the most expensive form of obtaining bankruptcy relief. After an individual or company files for Chapter 11, the administrative costs and burdens are manageable but can be significant. For this reason, Chapter 11 is not right for every situation. A company that is not a good candidate for Chapter 11 would be one where the expenses are exceeding revenues and the company does not have a reason to believe that things are going to turn around. A Chapter 11 bankruptcy would potentially add stress in this situation, not alleviate it. Good candidates for Chapter 11 might have one or more of the following issues. The business is fundamentally solid, but one or more creditors are being extremely unreasonable and need to be held at bay while the company negotiates with them. A Chapter 11 filing will stop an unreasonable creditor in its tracks and often bring the dispute under the control of the bankruptcy court. The company may have gone through a difficult period due to market forces or loss of a major customer or market, but is about to turn a corner and has a plan to do so. A Chapter 11 can provide some critical time or a breathing spell where creditors must stop their collection efforts and a reorganization can be negotiated and the turnaround plan conceived and implemented. An individual or company may have the ability to service the debt, but some of the debt needs to be rewritten over a longer term and the creditor or creditors will not agree. Chapter 11 can rewrite debt over a longer term while reducing or eliminating other debt. The company may be fundamentally sound, but it has agreed to leases or long-term contracts that are strangling it financially. A Chapter 11 can be used to reject contracts and leases and allow the company to downsize or find other business partners that are more profitable. The company or individual may be able to service debt if the secured debt reflected the value of the collateral or if the interest rates were reasonable. Chapter 11 can be used to strip down the amount of a lien to the value of the collateral or to reduce interest rates to market rates on some debt. An individual needs debt relief but has too much debt, too much income, or the circumstances are too complex for Chapter 7 or Chapter 13. After the reorganization concept is developed, a Chapter 11 plan must be filed and approved by the bankruptcy court. The mechanism for proposing and confirming a Chapter 11 plan is complex and requires a competent bankruptcy attorney who is qualified to handle complex business bankruptcy cases. At the time this video was published, Don Harris was the only attorney in the state of New Mexico nationally certified as a specialist in both business bankruptcy law and consumer bankruptcy law by the American Board of Certification. If you have a complex debt situation that could benefit from a Chapter 11 proceeding, you need a qualified bankruptcy attorney. Often, Chapter 11 is the only option available, and it can save a company or the financial affairs of an individual with a complex financial situation. Call attorney Don Harris in Albuquerque to answer your questions about Chapter 11 bankruptcy in New Mexico.